following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the fundamentals of the Public Property Act. How do the legislation in Sri Lanka adequately govern this area, and is there room for improvement? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Tonight's topic is something that in current context has been quite the conversation, and for us to get better context and understanding into this area of law that we haven't discussed on a series of episodes previously, and to speak about the Public Property Act and the Offences Against Public Property Act, we have with us someone that's very well suited for this specific discussion. I'm very pleased to invite on to the program Mr. Shiral, Lakthilaka, attorney at law. So thank you very much for coming onto the show today.
For having me in this program.
Thank you very much once again, sir. A bit of a breakdown into how we're going to be approaching this topic. First, we'll be talking about the fundamentals. Then we'll be going into the current context of what we can see. And finally, we'll be talking about what we can expect moving forward.
Hello, my name is Tisini Ayansa and I am a student in Gautami Badika Vidyalaya. So my question is on fundamental. What law governs the protection of public property?
All right, well, without any further ado, let's get right into this discussion. Once again, thank you very much, sir, for coming down to the studio today to give our viewers some understanding on the act in itself, because we haven't had much reaching, while there have been a lot of discussion related to the current context, the actual fundamentals of the law have not been discussed. So I'd like to start off with the very basics, specifically relating to the main objective of the Public Property Act, the Offences Against Public Property Act as well. Can you walk us through what exactly the act entails and what exactly its objectives are?
Now, this is a very stringent and far-reaching act which displays the offences against the public property. When you say public property, public property belongs not only to the state, but local government institutions, corporations, and other state-related institutions. So, this law was introduced in 1982, Act number 12. By this act, 40 years ago, still this act is relevant to us, because now when you look at the situation of Sri Lanka aftermath of the bankruptcy, there is a huge cry against manipulation and misappropriation of the state property. So, in this act, it talks about, first it defines 7 offences, right? Then it talks about the procedure, what kind of state property you have to misuse. Then what kind of offences and the penal liability for such offences. So, if you take at that time, it is very far-reaching. But nowadays we have the new laws such as corruption and bribery and corruption. Again, even you keep away the bribery, section 111 of the corruption, what you call Seabok Act, corruption, sections 112, 111, which is very much similar but go along with these kind of offences. Now, if you look at the 7 kinds of offences where this act is talking about, from the section 2 to section 5, it defines the 7 offences. Start from mischief against state property, then the theft, then against robbery, And also section 5 is very interesting offense, which talks about dishonest misappropriation. Not only dishonest misappropriation, it's about criminal breach of trust and forgery and falsification of accounts. So it's a wide range of offenses which can be committed against the state property. You know the state property because why we are doing so, or the state or intention of the legislature is that state property we keep, the public officials are keeping it as a trust. So when you have a trust, you are a trustee. The public officer is a trustee. So when you misappropriate, if you cheat that property, it becomes a liability. So it's a very interesting piece of law that could curb the misuse of public property, but also it deters. Because if you look at the offences, it's like this. The prison term is maximum of 20 years. And also the fine that could be imposed on the perpetrator is that the value of the damage 3 times of the value of the damage. So therefore it has very deterrent effect on penalizing a perpetrator. So very interesting law.
Exactly. And I want to ask you, sir, relating to, what public property in itself is defined as in the Act. Can you tell us about, what is actually covered under the term public property as mentioned within the Act?
Yeah, all public property belongs to the state, the local governments, corporations and boards, as well as it goes beyond even the semi-governmental institutions. So it is property like land or whatever, and also money. So all aspects are covered by this. So everything belongs to the state or semi-state institutions are under the scrutiny of this law.
So both movable and
immovable properties are liable or subject to this law.
Right. And now the other big term within this Act is a public officer.
Yeah.
Can you tell us now, we understand that a public property is defined as such, but a public officer, what is the definition given under the Act of who a public officer is?
The particular Act is not giving the definition, but we have to draw it from the existing law. So there are 2 kinds of laws applicable to define or definition of the public officer. One is Public Officers Liabilities Act. So that is also applicable here, and also the Constitution itself talks about who is public officer. So all those who are coming under those provisions are considered that as public officers under this Act.
So there is an understanding, even though there is no direct definition, we've drawn it from the
other general laws.
Right. And now you did skim over the 7 offences that you mentioned in the Act. Can we maybe go a little bit into more detail relating to the offences that are labelled in the Act, and how exactly the Act goes about with dealing with it, especially in comparison with our penal code, and how exactly the general offences are contrasted with these specific ones?
Now, this particular Act is a special Act. It's standalone Act. So the Act itself has stated 7 kinds of offences, and under the definition of the offences in the same Act has stated that the definitions given to these 7 offences under the penal code applicable to here also. Now, for instance, if it is a theft is defined and given offense, talked about offense under the penal code, it applicable to here. If it is a criminal misappropriation, same definition of the penal code. If it is a forgery, same definition of the penal code. So there is a parallel connection between the offences against the public property as well as the penal code when it comes to the definition of the offence. So it's go hand in hand with the two acts. One is general act, that is a common law act. Other one is special act. But when you compare these two legal legislations, the offences and the penal liability are different. Now here more severe. If you are doing a theft against the public property, the penalization is more severe than the penal code. That is the difference.
Exactly. I wanted to ask you specifically relating to how the offence's severity also changes when in comparison to how it deals with private property as opposed to public property.
Yeah.
You mentioned, of course, 3 times the value of the damaged public property is what is owed in terms of fines. Can you tell us exactly what the Act might be hoping to achieve by ensuring there is a harsher penalty towards the damage of public property or the offence done against public property as opposed to private property?
Now look, that's at the beginning I mentioned that now a public officer who is working under the government institution is holding that property belongs to the people. So he is holding that as a trust. So if you violate that trust, it's amount for a criminal offence as well as offence against the people, right? So therefore, severity is much more higher than what an individual is doing it against private property. So this is public money, public wealth. It was given under the trust. So if you are damaging it, so you are liable to more penalty than private property. So that is the rationale behind this whole the scope of the Public Property Act.
Exactly, and I want to take a short commercial break, but before we do that, sir, I wanted to ask you your opinion relating to the Offences Against Public Property Act. In your opinion, are there any key lapses that we can see in the legislation, or do you believe this is an airtight act? Do you believe that there is room for changes or improvement?
Yeah, you know that now this was done in 40 years back. Now definitions in relation to public property also evolved. Now take for instance, now we consider frequency also as a public property. Now your institution is having, your business is having based on frequency. Now is a frequency a public property? So we don't know. Still that kind of definition has not come through. So therefore it's high time to redefine the offence, not the offences, the scope of offences under this law. And by 21st century, lot of new phenomena have surfaced through the public governance and the control of the government.
Exactly. I want to get into the specifics of the current context as well, and what we can expect when it comes to the procedural aspects, also the special provisions. But before we get into any of such specifics, I'd like to take a short commercial break. You're watching Law, Land and Liberty. We'll be right back with the final segment.
Hello, my name is Anthony Kumar Metnali Biramona, who is currently studying in Cambridge School of Colombo. My question is on the current context. Is the legislation being used in a manner beneficial to the country?
Welcome back to Law, Land and Liberty. We're in conversation with Mr. Shiral Lakthilaka, attorney at law. Thank you very much, sir, for the previous segment. It's a good foundational understanding for us in order to understand what exactly the Public Property Offences Against Public Property Act is. Now I wanted to get into more of the current specifics, but before we do that, we would just getting finished speaking about why exactly there is a harsher emphasis on the repercussions towards damaging or causing offence to public property in comparison to the penal code and of course private property. Specifically when it comes to other pieces of legislation as well, we see quite a contrast despite there being lots of intersections. The special provisions on non-bailable offences under this Act. What exactly is the rationale behind this kind of segment that has been included in the Act, sir?
Yes, Section 8 of the Offences Against Public Property talks about this particular aspect. Now, the basic intention behind this provision is that to incarcerate the person who have committed such an offence until the end of the case. But you know very well, under our general law, the norm is to enlarge accused on bail. Principle, that is the norm. Incarceration is the exception. But here it is working other way around. So why such a harsh provision is introduced? To discourage a person. You know, in Sri Lankan legal system laws, the trials getting delayed, justice delayed very much. So therefore, in 80s, I think the drafters must have thought, until you wait for a final verdict, it's better to discourage public servants not to engage in this kind of behavior to damage the property what they are in trust. But interestingly, but still it says then there are certain exceptions. Now, if the ASP level, Assistant Superintendent of Police level person has to be certified first, this is the amount of the or value of the public property which is subject to this damage or alleged damage. Then the second is that if it is more than 25,000 only, Section 8 applicable, which says he has to stay in remand until the end of the case. But still, on special circumstances, that accused can go to the courts and ask to enlarge him on bail. So that is there. There is no complete shutting of the taking out before the trial, but you can ask for a bail on special circumstances. So therefore, one can argue it is a stringent law, and also it can say, right, there are certain exceptions. So that's how it has it is organized in this law.
Exactly. And previously we had this conversation relating to the currently emerging acts as well, and how there are similar provisions and similar penalties that can be mentioned for similar offences. Can you tell us how the Offences Against Public Property Act interacts with these almost correlated pieces of legislation? How exactly the two, is it cohesive or is it repetitive? What do we see right now?
Now it's a very interesting question, because now the penal code, our common law, general law, provides offences which talks about the offences against public property also, such as mischief, theft, robbery, misappropriation, breach of trust, everything is there. So the speciality is, when it happens against a public property, this special standalone act is in operation. One can argue, why do you want to do that? That's very interesting question. Still, we have no answer for that. There are so many other laws, special laws, especially like PTA, Prevention of Terrorism Act, also deals with damages for public property. So therefore, there are several other legislations that deals with public property. It's a choice of the police department. That is the area where we have to be very concerned, because when it comes to the selection of the offence and legislature, the police department or the investigators have a choice to formulate the offence based on various laws. Right? Now, when it comes to rule of law, we are talking about selective justice. That is very dangerous situation. In Sri Lanka, if you look at the general trend of criminal justice, it is well known that sometimes the impunity always prevails in our society. That is one problem. Because anybody who is powerful enough can escape from justice. That prevails for decades in Sri Lanka. On the other hand, what we observe, that selective justice is also a problem in Sri Lanka. So that, and also weaponization of rule of law. So if you want to incarcerate somebody for indefinite time, you can charge him under offences under the Public Property Act and say it is the damage goes beyond 25,000 rupees, so he should not be enlarged on bail. Let him stay in the prison until the case is over. So that is not rational from the eyes of criminal justice, because right of the accused is also a valuable thing. Right? You have to, now when you talk about criminal justice, there should be an equilibrium between the criminal justice and right of the accused. But in this particular act, the right of accused is gone very much below the expected level of criminal justice thing. So therefore, one can argue that this is a bit of draconian law which can be utilized to victimize your opponent. So that's a standard criticism leveled against this particular law.
Thank you very much for that, sir. I want to continue asking relating to not just how it intersects, not just how the Offences Against Public Property Act intersects with other acts, but also about the enforcement approach and judicial approaches as well, relating to the role that the Attorney General's Department plays when it comes to the prosecution of any cases under the Public Property Act. Can you please tell us about the role that the Attorney General's Department plays when it comes to dealing with public officers under this act?
Now, first and foremost, we must understand how this kind of action or act or offence go through the investigation process. So you know very well, under the Criminal Procedure Code, the police is responsible for conducting of the inquiry, gathering of information. According to this act, it is very well established fact that Attorney General has no role unless the court or police want to get their opinion, right? So straight away, police department can file an action under the 7 offences mentioned in the public, the act. But on certain occasions, if it is complicated, The investigation and the outcome of the investigation is complicated and difficult to place an offense, they can seek the opinion of the Attorney General through by themselves, or even court can ask to seek advice from the Attorney General. So therefore, my opinion, Attorney General has no direct hand in this investigation and constitution of the offense. Police can do that, but always the Attorney General could play a role here.
Exactly. And previously, when you mentioned, sir, when we were discussing about the intersection of these acts as well, you mentioned there could be, well, not necessarily malicious, but more of a controversial method of approach where there is discretion to pick the type of offence that we can prosecute under.
Of course.
When considering the lapses within our legislation as well, can this be considered something that needs addressing and fixing, or is it just because of the way that the law has developed in our country that it is a feature that we will have to, maybe make amends with?
No, that is why now I personally believe Sri Lanka needs a public prosecutor. There is a discussion going on within this present government also, and previous government also discussed this aspect. In order to avoid politicization of criminal justice, we need an independent investigative body and independent prosecution body. The Attorney General is not, under normal sense, he is the advisor to the state, right? So now the problem here is sometimes, not in this instance, Attorney General plays dual role. Now, you know very well that under the rule of law, I'm not talking about this particular aspect of offences, but under the social contract, it is considered notionally if a citizen has done a wrong to another citizen by theft or murder or whatever, it is considered, it is presumed that that offence is done against the state. That's why the state is indicting that person before the court, High Court. So when it comes to indictment, here Attorney General signs the indictment, but there are certain instances where sometimes the advisor to the state and the general prosecution is different from each other. So there is a conflict of interest sometimes, not always, sometimes conflict of interest may crop up. So that's why nowadays we are talking about the need of a independent prosecutor's office. But under the colonial time, this difference of interest between the, would say, state and the government. Now, government is one thing, state is one thing. Sri Lankan state, whatever the political party who is governing the state is government. That's why Britishers in Sri Lanka, they differentiate the role of Attorney General and Solicitor General. Always Solicitor General was at that time. As a tradition, he was responsible for criminal prosecution. Attorney General only signs that. So that's how that the division of labor was organized. But nowadays that division of labor has diminished, and we don't see, but still there is a Solicitor General in this country. So in that context, if you are moving towards 21st century, it's always better to have a prosecutor, public prosecutor. In South Africa, you have a public prosecutor. All modern day constitutions are having this kind of a new feature in prosecution.
Exactly. I want to get into what we can expect moving forward with our legal landscape in the future a little bit more in depth as well, and also to talk about the rest of the current context and the relevance that it has. But before we get into any of that, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back. Stay tuned.
Hello, my name is Himadya Sitni and I am a student in Gauthami Balika Vidyalaya. So my question is on the future, how can we expect the legislation to evolve with reforms moving forward?
Welcome back to Law, Land and Liberty. We're in our final segment in conversation with Mr. Shiral Lakthilaka, attorney at law. So thank you very much for the previous two segments. Unfortunately, we're at our final segment despite having quite a bit more that we can discuss, especially in relation to the current context and the developments that we have seen. But I wanted to ask you specifically relating to the effectiveness of the act that we have seen now. Practically, we see that there is enforcement approaches and the judicial approach is also existing. But now, considering our current context, do you believe that this act is effective in all its potential, or is there lapses? Because we see that at some points in time, there's really justice delayed, justice denied, and in certain instances, justice is quite swift. So I want to ask you, especially relating to the stability of this act, is it something that has to be come into question and restructured, or are we okay where we are at right now?
No, there is no wonder that there is a need of this hour to have this kind of stringent act or legislation, because you know that after the declaration of the bankruptcy, Sri Lanka has faced 4 kinds of social issues, out of which 2 are directly connected with this particular act. One is the debt. Why debt has accrued or accumulated up to that level? One can argue that that is because of the inefficiency or corruption of the state. On the other hand, the corruption and malpractices are rampant in our society. That is also contributed for this bankruptcy. So in that context also, one can argue this kind of stringent law is very much important. But the problem with this act is that there is a room for manipulation. That is the issue. So I think it's high time to look into this aspect and prevent using this particular act as a weaponization or weaponization of rule of law, or to bring selective justice to political opponents or any kind of person who is not in favor of public official. There are numerous allegations on this kind of situation, things. So therefore, if we can bring some checks and balances through the criminal procedure code or new procedure, especially when it comes to investigation and the constituting the offense before filing it to filing the charge sheet, that could prevent manipulating this kind of laws. So that is a need of the hour. We have seen in recent past also that police department using this particular act very famous situation is, you are well known now, citizens of this country know that the former president was charged under the Public Property Act, which there is one segment of the society thinks that it is unfairly charged. So therefore, what is needed is not only justice to be seen as justifiable. No? So therefore, still there is a lacuna. So it's high time to address that aspect. That is my opinion.
Exactly. And before we get into the final bits of the program where we can, ask you, sir, relating to what we can expect moving forward, I wanted to ask you this very curious question when it comes to our current context, specifically when it comes to the privatization or, of state-owned enterprises, the restructuring, that's also falling under public property and its protection. So does the Act actually adequately cover this area in order to prevent any loss of assets and maybe misappropriation of assets?
Yeah, one can argue that even falsification of accounts or breach of trust can be brought against this kind of behaviors. But I would rather argue it's always better in such situations to go to the corruption aspect and file under the new law, because when it comes to the section 111 of the corruption charge or under the Siobok law, it is all about making a damage or defect to the state, right? So that is much broader instead of working under mischief or criminal breach of trust. Much easier to charge against a perpetrator. So I feel that instead of using the Public Property Act, it's better to go to charge a person under the corruption instead of charging under the normal criminal law procedures.
Yes, and a question of curiosity as well, sir. When it comes to the effectiveness of enforcing what's entailed in the Public Property, Offences Against Public Property Act, do we see an effective enforcement, or do you believe that there are certain areas that restrict the Act, or are there obstacles in ensuring that whatever is stated within the Act is not properly enforced?
See, it is entirely discretion of the police department, no? Now, that's why I said at the beginning, this particular piece of legislature can used as a strategy to bring selective justice. So we all know that all over the country, if you go around the country, mischief against public property is rampant. But how many cases are filed under this law against those people? If the police and if the vigilant public are there may be numerous complaints. But how many cases you find or reported that these instances are filed against Public Property Act? There is no. Most of the time what we see is that whenever you want to charge a prominent person, a powerful person, this particular piece of legislation is used. So that is wrong. That is wrong, and that brings the concept or notion of selective justice. So we have to emphasize that that is not a correct practice under the rule of law.
Exactly, and you mentioned, sir, there's violations against public property or offences done towards public property constantly, and one such instance where we have seen major damage to public property was through protests that took place over the past few years in the country. How exactly is this kind of mass damage or maybe offence towards public property not done by certain select individuals but a mass group of people? How how is that handled under the Offences Act?
Now, it's very rare to recall that this kind of actions have been taken place, but I can remember somewhere after I think in between 2022 and 23, police has filed a case against a protester for damaging the tar in the road. It's funny, but they have gone up to that extent to bring those, maybe a trade union or student union activists into courts. So they use Public Property Act by saying they have damage to the road. So if the government wants, definitely they can do that, right? There is no hurdle, no restriction for that. So that is the two sides of this particular act. If you want to curb damage to the public property through trade union action or they can utilize it. On the other hand, if you want to curtail unwarranted, unwanted person to the government, that also can be done through this act. So it's a double-edged sword. So therefore, our opinion is that this particular legislation has to be handled with care.
Exactly. There has to be a lot of consideration before discretion on where exactly to apply. Leading me to my next and final question relating to what we can expect to see in the future when it comes to the development of this act and also for the legal landscape in general about maybe the malicious intent to utilize these acts, or will we see some sort of, as you mentioned, checks and balances or safety measures in place in order to ensure that proper justice prevails over whatever else agenda that is being perpetrated. Can you please tell us if you can see maybe positive changes, conversation towards maybe improvement or reform? What are we seeing right now, sir?
No, this is a very old act, the legislation, 40 years old. Now from there, 1980s from now, there is drastic changes have been happened. So you have to consider all kind of, as we discussed it at the beginning, the definition for public property. Then the role of the perpetrators. Now, if you know very well that public property is damaged through various, even under these 7 kind of offences, there are several parties involved there. Not only the public official, it is a responsibility of public official, then the politician and a businessman, right? 3 parties involved in damaging public property in Sri Lanka, or else, as you correctly said, the trade unions, political parties. How many property was damaged in past insurrections, right? So therefore, I think it's high time to consider all these aspects and see how we could evolve this particular piece of legislation to face 21st century challenges by the state. That is my opinion.
Exactly, and I think that's a great point for us to unfortunately have to end off our discussion on. Thank you very much, sir, for taking the time to come to the studio and explain this very vast topic to our audience, especially considering the current context as well. It's always best to get a better legal understanding of what the Act is before we get into any of the current information. So thank you once again, sir.
Thank you for having me, and I enjoyed the program.
All right, well, we'll leave you tonight with the words of Frederick Douglass. Where justice is denied, where poverty is enforced, where ignorance prevails, and where any one class is made to feel that society is an organized conspiracy to oppress, rob, and degrade them, neither persons nor property will be safe. That's all we have for you tonight on Law, Land and Liberty. If you had missed any of our programs, you can always rewatch by catching us on our YouTube page, youtube.com/otherderana-english. And please do share your thoughts and feedback with us through email at feedback.ad24english@derana.lk or via WhatsApp at 076-805-7933. Thank you very much for watching. Have a good night.